All right, so now without further ado, I'd like to introduce today's presenter. Alexandra Cantrell is a public policy manager on the legal sub-team at the Texas Council on Family Violence. Prior to joining TCFV, Ms. Cantrell worked at a domestic violence clinic during law school, preparing protective order applications for survivors of family violence and elder abuse. She briefly practiced law in both California and New York, prior to working as an advocate at the National Domestic Violence Hotline and at a domestic violence program in rural Texas. At TCFV, Ms. Cantrell's focus relates to survivors' interactions with the legal system and how those interactions can continue to be addressed and improved. So Alex, I will go ahead and let you take it away.
Great, thank you, Brooke. Let me just share my screen. Okay, and so hopefully everyone can see my screen at this point. If you can't, please feel free to chat in. Okay, as Brooke mentioned, I work at Texas Council on Family Violence, or as I'll refer to it throughout the presentation just for ease, is TCFV. You'll see our logo up at the top. For those who are unfamiliar with Texas Council on Family Violence, we are the Texas Family Violence Coalition. We have a large amount of members across the state that include a good portion of the family violence programs, as well as other stakeholders who, are really influential and beneficial to survivors' lives. So we have a couple of different departments. I am on the policy team. I've worked at Texas Council on Family Violence for about 4 years at this point, but we also have other departments that provide additional resources. So we have a prevention department that does a lot of community education and prevention work with prevention educators across the state, as well as a support to service providers department that does a lot of support for those family violence programs that are on the ground and providing those direct services to survivors. So I'm happy to be speaking with you today about this topic because we know it's topical and it really affects all of the work that we do as well as the communities that we live in. This is a particularly opportune time to discuss this topic with the recent gun-related tragedies in El Paso, Odessa, and Dayton, Ohio. So likely because 2 of those incidents occurred in Texas, there has been a lot of activity within all 3 branches of the Texas government related to guns. So if you're unaware of what's going on currently, and I'm right in the thick of it just based on my policy role, but Governor Abbott just issued 8 executive orders that are aimed at stopping potential mass shooters. In fact, he actually just released a full Texas Safety Action Report today with additional executive actions addressing firearm safety. Additionally, the Lieutenant Governor, Dan Patrick, he's been extremely vocal related to firearms and named a Senate Select Committee on Mass Violence Prevention and Community Safety. He has also identified multiple charges, including examining ways to keep firearms out of the hands of individuals who would not pass a federal background check. And then finally, the House is also at work. The Texas House Speaker, Dennis Bonnen, has asked a special committee to begin studying issues related to gun violence as well. And he has specifically directed the committee to evaluate options for strengthening enforcement measures for current laws that prevent the transfer of firearms to felons and other people who are prohibited by law from possessing firearms. So we'll talk a lot about that today. Before beginning, I wanted to be sure to mention that, looking at the registrant list and looking at the folks who are introducing themselves now, we have a couple of folks who are registered for the webinar who are outside of the state of Texas. I'm happy to have you here. I'm happy that you're interested in this topic. I did want to make sure to let you know that this training does have a focus on Texas. So there will be a lot of discussion about those Texas-specific laws. I will touch on some more federal laws as well as some best practices. But if you wouldn't mind using your raise your hand feature, if you're able to do so, to let me know if you are from out of the state of Texas, just so I can get a full idea of the folks that are on the call. Okay, so it looks like we have about six or so. Okay, perfect. So again, really happy that you're here. Just wanted to give you that heads up before so that you're just aware of the content of the training today. So as a quick roadmap for the presentation, I'll begin with providing you some background related to why it is so important that we're discussing firearms and family violence today. And then I'll go through some of the Texas-specific laws that relate to family violence, as well as prohibited possessors and the intersection with firearms. And then I'll go into some federal laws that must be followed across the country and that are not limited to only Texas. I'll also be touching on some Supreme Court precedent and guidance to provide some additional clarity to the landscape of the U.S. overall currently. I'll spend a little bit of time discussing the most recent legislative session, including what bills passed related to firearms. And again, this is going to be specific to Texas, as well as some that were proposed. So getting an idea of where folks are in terms of what they're thinking about related to firearm legislation. We'll also spend some time talking about best practices and considerations for different disciplines when it comes to working with survivors who may have an abuser who's utilized firearms to either threaten, hurt, or coerce. And toward the end of the presentation, I'll touch on some practical implications of surrendering firearms and some pieces to think about when considering a surrender protocol in your community. Okay. So to begin, across the country, 1 in 4 women will be victims of family violence at some point throughout their lifetime. On the other hand, in Texas, the number is 1 in 3. So with a population of over 13.5 million women in the state of Texas, it's really clear that there are many Texas women who will be affected by family violence at some point in their lifetime. Texas Council on Family Violence works on a publication every year called Honoring Texas Victims Report. And this report identifies women killed by male intimate partners in Texas to both honor their memories, but also to raise awareness and identify those trends that we're seeing. TCFV has been doing this work for almost 40 years, and over that time, more than 100 women have lost their lives each year. I did want to just identify for you that the data that I'm going to be talking about is from 2017. Our new report will come out during the month of October. So for Domestic Violence Awareness Month, that will include some numbers for 2018. So just be aware that these are the numbers that I'm referring to. So in the most recent iteration that was released in 2018, Texas Council on Family Violence identified that 136 Texas women were killed in 2017 by a current or former male intimate partner. They ranged in age from 14 to 84 years old. So it's clear that this issue affects women of all ages. It's really not limited. What is more astounding is the fact that 65% of those 136 women who were killed by a firearm. So more than half of the women who were killed by an intimate partner in Texas in 2017 were shot to death. So based on research that was done in 2016, the presence of a gun in domestic violence situations increases the risk of homicide for women by 500%. The substantial increase in danger by the mere presence of a gun is really important to note. Besides the increase in homicide and violence, we also know that wielding a weapon, in particular a weapon as deadly as a firearm, can create influence and assert dominance, particularly in interpartner relationships. Additionally, simply knowing that an abusive partner has access to a gun can signal a credible risk that instills fear, regardless of whether that partner has been physically violent up to that point. So while the presence of firearms are a clear risk factor for future violence and potential homicide, another risk factor is ending or attempting to leave the relationship. So many folks are quick to say that domestic violence survivors should just leave, and why don't they just leave? But leaving does not always equal safety in a lot of cases. So our Honoring Texas Victims report found that of the 136 women killed, 37% of them had made attempts to leave or were planning to end the relationship. As you can see by this chart, female intimate partners are more likely to be murdered with a firearm than all of the other means combined. So you'll notice we also have stabbed, strangled, physical assault, or something other than those four, and still more than half of those individuals were killed at the hands of a firearm. Again, the percentage of perpetrators who used a firearm to murder their female partner was 65% in Texas, while the national average is 53%. So again, you can see it's still very high across the country, more than half, and in Texas quite a bit higher in this past year. In addition to the female intimate partners who were killed by their abuser, family violence claims a lot of other collateral victims. Law enforcement officers are one of the most common collateral victims. Domestic violence calls lead to more officer deaths than any other type of call. Additionally, and we'll talk about this in some greater detail, but the majority of mass shootings involve family violence in some way or have some intersection with family violence. And like I said, we'll spend a little bit more time on that. As you can imagine, children are often the most common victims of domestic violence mass shootings by injury, death, or the loss of a loved one or a parent. As we found in the family violence homicides from 2017, beyond the 136 women who were killed, 7 other individuals were injured, 15 others were killed, and 211 children lost a parent. So as I'd mentioned before, we know, and I would imagine most folks on the call know, that there's a clear connection between intimate partner violence and mass shootings. So research reveals that over half of recent mass shootings, defined by the FBI, and just to be clear, it's a shooting in which the perpetrator kills 4 or more people, not including themselves. But many of them involved intimate partners or other family members. So in the United States, family violence offenders accounted for 54% of the mass shooting perpetrators from 2009 to 2016. Additionally, between 2009 and 2017, at least 491 people were shot and killed as a result of mass shootings related to domestic violence or family violence. And in nearly half of those cases, the perpetrator exhibited warning signs before the shooting, including having been previously charged with a family violence offense. As you can see, many recent mass shootings have had a family violence connection. So you'll notice Sandy Hook, and if you remember that horrific shooting, the shooter killed his mother before the school shooting. The Pulse nightclub shooting in Orlando, the shooter beat both of his wives in the past. The Sutherland Springs shooter, he was discharged from the Air Force for domestic abuse, accused of sexual assault, and should not have been in possession of a firearm. The Las Vegas shooter had abused and berated his girlfriend in front of others. The Parkland, Florida high school shooting, there were many domestic violence disturbance calls from the shooter's home, in fact 36 between 2010 and 2016. And the shooter abused and stalked his girlfriend and assaulted and threatened to kill her new boyfriend. And then Santa Fe in Texas, the first student who was killed was a girl who had recently spurned the shooter's romantic advances. And then finally, most recently, the shooter in Dayton, Ohio, the first person that he killed was his sister, and he had also threatened female classmates with violence. So although the obvious concern when it comes to firearms is homicide or injury from the discharge of that firearm, there are also non-fatal uses of firearms that abusers utilize to scare or threaten their intimate partner. For a few examples, 4.5 million women in the U.S. have been threatened with a gun by an intimate partner. An additional 1 million have been shot at or survived a gunshot wound from an intimate partner. And a victim that was previously threatened with a gun by their partner was 20 times more likely to be murdered. So with all of that background, let's spend a little bit of time talking about the Texas firearm laws that relate to family violence. So in Texas, there are a few prohibited offender designations that relate directly to domestic violence. The first prohibited possessor is anyone who is a convicted felon during the 5-year period after they're released from prison. So that's important to note. After that time, based on Texas law, a convicted felon is able to only possess a gun at their home. So after those 5 years, after the release from prison or probation or parole, a convicted felon in Texas, based on Texas law, is able to maintain or possess a gun at their home and not anywhere else. The penalty for violating this would be a third-degree felony. You'll also notice the Texas description of possession is intentional or knowing care, custody, control, or management. So none of these pieces must be exclusive, which means that even if the weapon was being shared or was in the possession of a licensed gun owner and the prohibited possessor, it would still be considered a violation. Under Texas law, another prohibited possessor would be a person who's convicted of a misdemeanor assault involving a family violence member, or a family member, a household member, or a dating partner. Again, this would be during that 5-year period after the release from jail or probation, and the penalty for a violation would be a Class A misdemeanor. And you'll see that that could be 1 year in county jail, potentially 1 year in county jail. Also, I do want to note, don't worry about, if Brooke has not already sent these out, I know that is the plan. And so I know that there's a lot of legal language. I'm going to be providing a lot of, different pieces. I don't want you to have to be taking furious notes to be able to take all this information down. So you will at some point be able to access these slides. So let's see. The final prohibited possessor under Texas law related to family violence is a protective order respondent while that protective order is active. So this includes emergency protective orders, permanent protective orders, among some other type of protective orders that are listed there. The one thing to note is that this does not apply to peace officers while they're on duty. So if they have a protective order against them, they're still able to possess a firearm while they are on duty based on this Texas law. There are also some required language pieces that must be included on each protective order that's issued under the Family Code, which basically state that it's unlawful for any person, with the exception of a peace officer, as I've mentioned before, who is subject to a protective order to possess a firearm or ammunition. So if the violation is civil in nature, the penalty is up to $500, 6 months in jail, or both, while a criminal violation could result in a fine of up to $4,000, 1 year in jail, or both. As I'd mentioned before, excuse me, it's a crime in Texas for an abuser to possess a firearm if an active protective order is in place. In these instances, the person subject to the protective order must have notice. So they must have been served, they must be aware of the protective order, and they must have an opportunity to participate in a hearing. So again, those are some important pieces to remember when it comes to that prohibited possessor piece. Now, there is an enhanced penalty if a person violates a protective order 2 or more times in the period of 12 months or less. So if someone who is a respondent in a protective order and is found with a prohibited firearm 2 or more times in a 12-month period, the penalty could increase to a third-degree felony, which could result in 2 to 10 years in prison and up to $10,000 fine. In Texas, there's also restrictions on individuals selling or transferring firearms or ammunition to a prohibited possessor. So it's not just solely on that prohibited possessor. There are some additional protections or requirements for folks to not be selling, renting, leasing, loaning any firearm or handgun to a person who's subject to a protective order, or knowingly receiving a handgun from someone who is subject to a protective order. So you'll notice that the language differs slightly and can come across a little confusing to someone who's not as familiar with these restrictions. And also another thing to note, there is no clear unlawful transfer law related to those convicted of a family violence misdemeanor. So there's really a focus on the felony aspect as well as the protective order aspect. So when it comes to handgun licenses and protective orders, The court shall, which basically means must, suspend the license to carry a handgun held by the person who is subject to that protective order. On the other hand, in the case of a stalking, sexual assault, or trafficking protective order, the court may suspend the license, which means that they do have a little bit of discretion in those cases. While there are not notices explicitly required under federal case law, there are some Texas notice requirements. You'll notice there are quite a few, and you'll notice that they're sometimes looking slightly different depending on the circumstance. Still, there are notice requirements to help ensure as much as is possible that prohibited possessors are aware of the restrictions being placed on them. And as an additional aside, I think that's another area that Governor Abbott has mentioned, wanting to be a little bit more clear, is letting those folks know who are prohibited possessors that they are in fact prohibited possessors. As I've mentioned, the Texas prohibition and notice language is inconsistent across Texas law and differs from federal law. So I won't read through all of these different notices, but they're here for you to reference. And I will point out that some mention that the prohibited possessor may not possess firearms or ammunition. Some say just firearms. Some mention prohibiting transfer, while some mention only possession. So you can certainly understand why this may be a confusing message to not only the person who is prohibited from possessing, but also folks who are trying to enforce Texas law. And so with that, I'm going to get into some federal firearm laws, which generally will take precedent over state or local laws. But before I get into the federally prohibited possessor laws, if you could chat in about whether you think Texas is more restrictive with their firearm prohibitions or less restrictive than who is restricted under federal law. I'm curious to see thoughts. I know that there are, feelings when it comes to Texas generally, as compared to, other states across the country. All right, so I have somebody who's referencing less restrictive. Okay, so like I said, I think there are some feelings related to Texas, related to some looser gun laws, and I think that's the case in a lot of ways. But surprisingly, there are some areas where we are a bit more restrictive or a little bit more broad in terms of who are included in prohibited possessors than in federal law, as well as some areas where we're a little less restrictive. And I'll be sure to touch on those. But thank you for participating. So again, under federal law, there are also different types of prohibited possessors. Felons are not able to possess firearms. So this is one area where it is more restrictive federally, because I'd mentioned to you that 5 years after they have left jail, probation, or parole, that in Texas they are able to possess a firearm in their home. That is not the case under federal law. So after their release, they are not able to possess a firearm in their law. So again, a very different thing to remember, that because under federal law, and that typically will trump, felons are never able to possess a firearm after being convicted. Additionally, since 1994, a respondent in a qualifying protective order may not possess a firearm. So this is a very similar requirement as is in place in Texas of ensuring that the respondent had notice and an opportunity to participate in the hearing. So these, again, are pieces to keep in mind. And this is the place where Texas is a slightly more restrictive, because under federal law, this will only qualify in protective orders between a spouse, former spouse, people with a child in common, or people have resided together. So you'll notice that one person or one type of relationship that's not included there is a dating relationship. So if they haven't lived together or have a child in common, then they're not included in this particular prohibited possessor piece. While in Texas, a dating partner is included. The Lautenberg Amendment, also known as the Domestic Violence Offender Gun Ban, this took effect in 1996 and is named for the amendment sponsor, so Senator Frank Lautenberg. Senator Lautenberg was also quoted as saying, "The difference between a murdered wife and a battered wife is often the presence of a gun." So a pretty powerful quote, and also a pretty powerful amendment. So the Lautenberg Amendment is similar to that prohibited possessor piece I talked about in Texas of, limiting or prohibiting any person convicted of an offense involving misdemeanor domestic violence from owning or possessing firearms and ammunition under any circumstances. So the family violence language doesn't need to be specified, but the offense must have been committed, again, that federal piece, against a current or former spouse, parent or guardian, current or former cohabitant, or by a parent of a child in common. Now, again, keeping in mind that the dating partner is not included in that language. So this would create a lifetime prohibition for all people with a penalty of up to 10 years in prison for a violation. Additionally, law enforcement officers and military personnel are subject to this law. Another federal regulation is the Federal Gun Control Act. So the Gun Control Act is a U.S. federal law that regulates the firearm industry and firearm owners. So it's primarily focused on regulating interstate commerce or passing guns over state lines by prohibiting the interstate transfers of firearms, particularly to those that are prohibited from possessing a firearm or ammunition. And you'll see here the penalty is the same as underlying offense of the abuser. So now I'm going to talk a little bit about case law. This is quite a bit older of a case. This is a Supreme Court case that involved a Second Amendment challenge from 1939. It was challenging the National Firearms Act of 1934 against the transportation of sawed-off shotguns. So the court found in this case that federal and state governments could limit any weapon that did not have a reasonable relationship to the preservation of a well-regulated militia. So again, if this particular firearm was not able to be proven to have a reasonable relationship to the preservation of a well-regulated militia, then there could be some limitations on it. In this instance, they could not take judicial notice that a shotgun having a barrel less than 18 inches long has any reasonable relation to the preservation or efficiency of a well-regulated militia in the absence of any evidence showing that relationship. So this one's important to remember, mainly for the fact that there are some abilities of state governments and federal governments to limit particular weapons. So the court determined that they could not say that the Second Amendment guarantees a citizen the right to keep and bear this particular weapon. So, of course, as you can tell from the picture of the court that was on the bench at the time of this particular case, it's pretty old, and there are some more recent decisions that are also important to be aware of, and so I'm going to share those with you today. So more recently, and this one is from 2014, is United States versus Castleman. And so this case challenged the application of the law to misdemeanor convictions which did not involve the use or attempted use of physical force. So in a unanimous decision, this United States Supreme Court held that the Castleman conviction, so it was a conviction of misdemeanor domestic assault, qualified under one of those misdemeanors in the Lautenberg Act that would be a misdemeanor crime of domestic violence under Tennessee state law. So this was a case that came from Tennessee. The court specifically held that the physical force requirement is satisfied by the degree of force that supports, that level of common law battery that was laid out in Tennessee state law. So more specifically, that offensive touching would qualify and meet the requirement for that misdemeanor crime of domestic violence. So that prevented this particular individual from possessing a firearm under the Lautenberg Amendment. This case turned on the definition of physical force and the Tennessee assault statute, whose definition specifically was intentionally or knowingly causing bodily injury. So as an aside, the Texas assault statute actually is very similar, but goes a step further and adds an additional mental state element. So not only is it intentionally and knowingly, but it's also recklessly. So this particular case would easily stand up under this particular decision in Texas. Now, for those who are not familiar, intentional force in the crime of domestic violence is typically pretty clear. It'll include punches, slaps, strikes, and other forms of physical violence. Additionally, that intentionally and knowingly piece, or a force used with knowledge, also tends to be a little easier to define. So an offense that's committed knowingly is defined as an action where the defendant is aware that harm is practically certain. But recklessly is a little bit more nuanced. So the next case I'm going to discuss addresses this additional mental state variation of reckless behavior that was not addressed in Castleman, but is included in our Texas misdemeanor assault statute, and likely in some of the other folks who are attending in your state's misdemeanor assault statute. So the case I'm going to be speaking about that addresses that is Voisin versus United States. So this is the United States Supreme Court from 2016, so a couple years after Castleman, in which the court held that the domestic violence offender gun ban, so that misdemeanor lifetime gun ban, in the U.S. federal law extends to those convicted of reckless domestic violence. The court reached a decision. It was not unanimous, but it was 6-2, so it was a majority. And the case was based on a situation from the state of Maine that has a very similar misdemeanor assault statute as Texas. So what I mentioned before is that intentionally, knowingly, and recklessly. That additional aspect of reckless mental state I mentioned in the previous case was addressed in this case. The majority on the court found that reckless assault, as in assault or force where a defendant ignores the propensity to inflict injury. So they're doing something and ignoring the fact that the outcome could be an injury, that it qualifies as a misdemeanor of domestic violence for the purposes of the lifetime federal firearms ban. There was also some clarification that reckless does not mean an accident, but it does involve a deliberate decision to endanger another. Another thing to remember about this particular lifetime firearm ban is that it can be triggered even if there's no harm to the victim. So for example, it can be considered a reckless use of force to throw a plate at a wall near a victim, even if that victim is not injured by the plate, because there is that substantial risk that a shard from that plate or that plate could ricochet and injure the victim. Okay, and now I'm going to get into some more recent Texas firearm legislation. Okay, so for those who are not aware, Texas holds a legislative session every odd year from approximately January through June. We just completed the 86th session this past winter and spring, and most bills that passed went into effect on September 1st, 2019. So a lot of these bills that I'm going to be talking about that have passed are currently in effect and have been for the past 12 days. I'm going to share a few gun-related highlights and changes that have occurred, and also talk a little bit about the gun bills that were proposed that didn't actually make it to the governor's desk. So as a bit of background related to how we got these numbers that are on the screen right now, Texas Council on Family Violence, we monitor every bill that's filed throughout the session, and we identify the bills that may affect family violence survivors, either directly or indirectly, and then we take action when necessary. This monitoring process is certainly not foolproof, given that there were approximately 7,400 bills that were filed this session. But this is an approximate number of the gun bills that were filed versus those that were passed. So as you can see, there were approximately 52 gun bills filed. And again, we are Texas after all, and only 6 gun bills that did in fact pass. Some of the proposed firearm bills that did not land on Governor Abbott's desk are listed here. So again, as I mentioned before, I'll be sure to provide this slide deck to Brooke to distribute, so you'll be able to reference back to this list and some of the law language, the considerations I'm going to provide, as well as some of these proposed bills. But I do want you to keep in mind that all of the bill topics that are listed here are not law at this point, because these did not make it through both chambers and were not signed by the governor. So although there were approximately 52 gun bills filed, there were a few of the bills that more directly affect family violence survivors, and those are the ones I'm going to mention for the most part, as well as some interesting additional ones. So first, the creating of a criminal offense, if a firearm goes off and injures someone, whether that discharge was accidental or not, was one of the proposed topics. Also, notification to the Department of Public Safety, or DPS, if a prohibited possessor attempts to purchase a firearm. So this is a piece that I think has a lot of traction at this point, and people are talking about, but it was not something that ended up passing. Another bill that was proposed that's gotten a lot of traction recently, particularly with the most recent mass shootings, are extreme risk protective orders, or sometimes called red flag laws. So for those who are unfamiliar, an extreme risk protective order is aimed at permitting the police, family members, community members to petition a state court to order the temporary removal of firearms from a person who may present danger to others or to themselves. So this proposal is particularly controversial generally based on what folks say is an alleged lack of due process or lack of violence, frankly, prior to the order of removal. Again, though, it has been something that's been talked about a lot. There are some states who do have red flag laws or extreme risk protective orders in place, and it was discussed this past session in Texas. So there was also a bill related to an exemption from federal regulations for Texans because of, we're Texas, so we shouldn't have to follow those federal regulations. Again, that one didn't move very far. Another bill related to a public awareness campaign related to firearm safety and safe storage. And so this was really just hoping to be able to create some educational materials for folks related to firearm safety and safe storage of firearms. Another proposed bill that was somewhat embroiled in controversy from the start was the constitutional carry bill. So it is one of the more extreme proposed gun bills. There are some states that have constitutional carry in place, not too many, but it was heavily advocated for by many gun rights groups. And this bill would have allowed open carry of a firearm without a permit unless otherwise prohibited by state or federal law. So basically, you wouldn't need a permit to carry as long as you weren't a prohibited possessor. So there was some interaction between a gun rights group and some House members, and the sponsor of this bill announced that he was officially canceling his request for a committee hearing. So as you can imagine, it did not move forward at that point. There were a few bills that were related to fees associated with owning a firearm, both a proposed increase in those fees, as well as some removal or elimination of those fees. There was a bill related to requiring the reporting of a stolen firearm within a particular time frame, and some suggested procedure for storage of those firearms that were surrendered voluntarily. There was also a bill aimed at removing the prohibition of carrying a firearm into a place of worship. There was a bill that ended up passing that's similar to this one that I'll talk to you about. There was a bill proposed the removal of some barriers to gun ownership. So currently there's some barriers to gun ownership if you have or owe outstanding child support or taxes. This was proposing to remove that barrier. There was also some bills that were prohibiting public funds from being used to enforce certain federal laws regulating firearms. And then there were some that were tax exemptions for firearm safety devices and other educational materials. As you can tell, there were a lot of proposed gun bills, and they were from both sides of the aisle. So I think everyone generally, particularly in Texas, is talking about firearms in some way. Now for some of the bills that are currently new law in Texas. So of course, these will be a little bit more important to note. And I'm going to go through these bills pretty quickly just to make sure we're able to fit all the content in for the day. But if you do have a specific question about a bill, and how it may affect your work or your community or any nuance about it, my contact information will be at the end of the training, and I'm going to be more than happy to follow up with you regarding any inquiries you might have, particularly if they're more specific to your local community. Okay. So I wanted to mention that while I said 6 gun bills passed, I'm going to be talking about more than just those 6 gun bills. That's because I have included a few bills that are somewhat gun-related or have a correlation to guns and family violence, but we didn't classify directly as gun bills. So the first bill I'm going to talk about is SB 535. So I know that I mentioned a bill related to removing the prohibition of carrying a firearm into a place of worship that did not pass. But this bill essentially changes the penal code to make it clear that places of worship are to be treated the same as any other private property when determining whether a license holder may carry on the premises. So to be clear, churches would still be able to prohibit licensed citizens from carrying firearms on their premises as long as they provide oral or written notice. But there's no longer that broad prohibition from entering a place of worship with a firearm. The next bill I'm going to talk about is HB 302. Now, this particular bill limits apartment and condo owners' ability to prohibit tenants from carrying or storing guns in rental housing. So this is essentially removing the ability for apartment or condo owners to make a complex, entirely firearm-free or a firearm-restricted property. So this bill allows tenants or those who are renting in rental housing to be able to transport their gun from their car to their house, from their house to their car, and other little pieces like that. So again, it's not prohibiting the your property owners are no longer able to prohibit the carrying or storing of guns entirely in rental housing. HB 121 creates a defense for a person who's brought a handgun onto a property that forbids entry on the premises with a handgun, as long as that person leaves the premises after receiving an oral notice. So basically, if a person enters a property that forbids entry with a handgun, so has a sign and does not allow someone to come in with a handgun, as long as that person leaves after they receive an oral notice, then they're going to have a defense to prosecution for the trespass with a handgun. HB 2363 removes the restriction for foster homes of having to store their firearms and ammunition in separate lockboxes. So previously, part of the review process for a foster home is that any firearm or ammunition that they had to be stored in separate lockboxes. So the firearms in one, the ammunition in another. Now, based on this new law, they can be stored together, but still properly stored. HB 3231, this prohibits municipalities and counties from creating local laws or ordinances that limit or restrict the sale or transfer of firearms, air guns, knives, or ammunition. So basically, any additional, more restrictive laws outside of the state and federal laws are not allowed to be created by municipalities or counties related to the sale or transfer of firearms. As a brief aside, TCFD actually worked with the sponsors of this bill to include language that ensured that this bill did not limit the enforceability of any state or federal law. So we wanted to do this to ensure that there was no confusion around whether a municipality or a county is able to put a surrender protocol in place or anything else related to enforcing the already in place state or federal laws. So just to be clear, this does not limit the ability for a county or municipality to put protocol in place to enforce state or federal laws. HB 1177 allows individuals to take their guns with them without a license during an emergency evacuation. So I believe it's during the 48-hour emergency evacuation time frame, individuals are now allowed to carry firearms without a license. So it doesn't mean that they shouldn't have a license to possess the firearm. It's just that they don't have to have the license with them. That being said, it would likely be a little bit harder for any enforcement if someone didn't have a license based on this new law. So as for the bills that are gun-related, but are not necessarily very strictly gun bills, I'm going to start with SB 415. So this was actually, it did not pass, but it was added on to HB 1528, which I'm going to speak about in a moment, by way of an amendment. But this particular bill requires that all misdemeanors that are involving family violence, so you'll remember I spoke about family violence misdemeanors before, and how someone who's charged with a family violence misdemeanor is a prohibited possessor in Texas, is that those individuals have to enter their guilty plea in open court in front of a judge. So previously, there were some fine-only cases where they were pleading, but it was only a fine, and they were allowed to plea by mail. But now that exemption has been removed for those misdemeanors involving family violence. So this now allows for a judge to provide a full admonishment in person related to that defendant's prohibition from possessing a firearm based on their guilty plea. So this really just is an additional piece of notice that a judge has the ability to provide to someone who is not able to possess a firearm. So just another layer that can be helpful in making it very clear to those who are prohibited from possessing that they are in fact prohibited from possessing. HB 1528, which is the bill that SB 415 was amended onto, requires that the Department of Public Safety, or DPS, enter whether or not a judgment reflected an affirmative finding of family violence into that state database, which would then limit that defendant's ability to potentially purchase a firearm in Texas and maintain a license in Texas, so a firearm license. So it's just a requirement now to ensure that that information is being entered into that criminal history system. And then finally, HB 1387. This one's a bit nuanced, and I thought it was important to mention, particularly when it comes to dating violence. And some of the mass shootings, to be frank, that we have seen have been on school campuses. So prior to this bill's passage, public schools were able to designate school marshals who could carry guns on campus. They're typically not known by the rest of the campus, but you're able to designate individuals who already work at the school who could carry guns on campus. It was previously limited to one marshal per 200 students. So this bill has removed that limitation of one marshal per 200 students. So now public schools have the discretion and ability to designate more school marshals and therefore potentially increase the amount of faculty that are able to carry guns on campus. So now before we move away from the 86th legislative session, I wanted to share a little bit about TCFV's agenda. So every legislative session, TCFV holds a legislative agenda with particular topics and bills that we're supporting and we're involved with. We identify our agenda by bringing together stakeholders across the state from all disciplines to determine what the needs of Texas survivors are. So this past session, one of our bills was related to the creation of a firearm surrender protocol for prohibited possessors, particularly family violence-related prohibited possessors, by each county in the state. Our bill was filed in the Senate by Senator Royce West and in the House by Representative Joe Moody. We understood that all communities in Texas are extremely different, and if you're from Texas, you know this, and they require different processes. So this bill focused on allowing each community to come together to enforce the already established state and federal laws requiring firearm surrender for prohibited family violence offenders, with some required aspects and guidance within the statute language. So first, there were some specific community members that were identified as important to be involved in this process and therefore recommended to be a part of the task force that was created. There were also certain aspects of firearm surrender that had to be discussed when the task force was created, such as storage and notice. So some of those logistical pieces that are really important when it comes to putting any type of surrender protocol in place. The bill's goal was for each community to come together and propose a surrender protocol that would work in their community, but there was no implementation requirement in this bill. We were really trying to start from the very bottom because there's plenty of communities, most in fact, across the state of Texas that have no surrender protocol in place. Even though those prohibited possessors are not to possess firearms and should surrender them, there's just no process in place for that to actually occur. So it's right now just an obligation on the part of that prohibited possessor. So the hope of this bill was to bring those necessary parties together, start on the path toward a successful surrender protocol. So really just starting that path. So while HB 3191 did get some traction, and we received a hearing in the House Homeland Security and Public Safety Committee, it ultimately stalled after that hearing. So we received a lot of great feedback, and we're able to have some really great conversations with key House members and senators. So we're really hopeful to be able to move forward and maybe get a little further if this remains a priority for our stakeholders. So before we get into some best practices, I wanted to identify some of the federal and state loopholes around gun sales and prohibited possessors. So this is something I think that has been talked about quite a bit, particularly in the context of VAWA, the Violence Against Women Act, and that reauthorization, as well as just things relating to gun sales with the incidents that have occurred recently. So the first one is the gun show or online loophole when it comes to private gun sales. So at this time, both federally and by Texas state law, unlicensed dealers do not need to perform any background checks. So this accounts for a good portion of the guns that are sold in the U.S. and almost 1 billion websites that sell guns. And also, as a note, the Odessa shooter had purchased a gun from someone who did not require an unlicensed dealer, who did not need to perform a background check because he would have not passed that background check and been able to purchase that firearm. Another loophole is referred to as the boyfriend loophole. And so this is the one I had mentioned before, where there is a slightly higher level of protection when it comes to Texas versus federal. And this is what I'm speaking about. So you'll notice that I provided the definition of domestic abusers when I spoke about the federally prohibited possessor regulation. And that definition does not include a dating partner if they do not share a child or cohabitate. And so that means that a dating partner may not be prohibited from possessing a firearm under that family violence misdemeanor or protective order federal regulation based on their relationship to the victim, because they don't meet that requirement. The same can be said for those offenders who are convicted of stalking, because if they don't meet one of the other requirements, so a spouse, a former spouse, a cohabitant, or sharing a child in common, then they would not be prohibited from possessing a firearm. So that's why they call those the boyfriend loophole and the stalking loophole. So now we're going to get into some best practices in terms of family violence and the intersection with firearms. So this is going to move a little bit away from, Texas specific. Of course, this is relevant to everyone, but it's a little further away from those Texas specific laws for those folks who are not residing in Texas. So first, the utilization of the Crime Information Database. So these databases, the national ones, so the National Crime Information Center, as well as the Texas Crime Information Center, or TCIC as I'll refer to it, and I'm sure that there are these types of crime information centers in everyone's state. They were developed to be an up-to-date repository of protective order information for courts and for law enforcement to access. So these databases are not subject to an open records request, and they're really just for the benefit of those who may be responding to an incident or determining a penalty. So again, limited to the courts and law enforcement. The database provides information about domestic violence provisions, including protective order information from all states, so talking about that National Crime Information Center, felony warrants, and the existence of domestic violence convictions. So this really allows for law enforcement to be aware of the firearm prohibitions or protective orders that are in place before being on scene of a call or disturbance. This is really important for the protection of law enforcement as well as the community generally. When this information is not entered or is entered inaccurately, there may and could very well be safety issues for the victim of the crime, for law enforcement who are responding, and for the community as a whole. So again, it's really important that these are at the forefront and that there's procedures in place to make sure that this information is being entered quickly and accurately. So as such, it is a best practice to ensure that this information is being entered in a way that is the best for the safety of the community. Another topic I'm going to discuss are federal background checks. Again, I feel like all of these topics are extremely poignant at this point, but since 1998, the FBI runs all firearm transaction background checks through the National Instant Criminal Background Check System, or NICS. So they are running these checks 17 hours a day. And on Black Friday of 2017, they actually processed 203,086 background checks. So one piece to keep in mind is that this number is not indicative of the amount of guns that were purchased. The check relates to each background check transaction, but an individual could have purchased more than one gun within that transaction. So again, keep that in mind. Now, Texas and many other states do not have a state expanded background check requirement, and they do not require private sellers to run a background check. Also, federal law does not require dealers to conduct a background check if a firearm purchaser presents a state permit to purchase firearms. So this is important to think about because of that, handgun license holders in Texas are exempt from a federal background check requirement when purchasing a handgun. The concerning aspect of that is that people who've become prohibited from possessing firearms may continue to hold their state firearm license if the state fails to remove those licenses in a timely fashion. So it is possible that someone who's prohibited from possessing firearms, is prohibited from purchasing firearms, may still have that license available if it's not removed, and be able to not run a background check and purchase a firearm. So again, this allows those prohibited possessors to continue to purchase firearms without a background check. I've also included a background check as a best practice because in the 19 states and in DC that require expanded background checks, 47% fewer women are shot to death by an intimate partner. So there's a clear correlation with more expansive or expanded background checks required. So the general public is actually generally in favor of background checks, which may be surprising to some of you. It was to me at first, but I think it makes a lot of sense. So shortly after the shooting in Newtown, Quinnipiac University began conducting a poll that was related to firearm background checks. And as recently as 2018, approximately 97% of the people who were surveyed were in favor of background checks for all gun buyers. So that includes those private gun sales. So that's a really high number. And again, a really, really great best practice would be to expand those background checks to ensure that those private gun sales are requiring background checks in some manner. So finally, a few other promising practices and some statistics that are associated with them are listed here. First, states with gun restrictions for emergency restraining orders in domestic violence cases have a 12% fewer intimate partner murders. Also, laws that require law enforcement to issue gun permits were linked to an 11% reduction in gun-related intimate partner murders. And then laws that prohibit people with domestic violence restraining orders from owning guns were linked to a 22% reduction in gun-related intimate partner homicides. Now this last stat I think is really telling, particularly for someone who worked on a firearm surrender protocol bill. But while the gun-related intimate partner homicide rate in states that banned gun possession for offenders of family violence did not drop significantly, those states that required the guns to be surrendered, the rate dropped by 14%. So the key to a lot of these laws are going to be how it is enforced. So I'm going to spend a little time talking about the ideal of how to create a firearm surrender protocol in your community, specifically some places to start and questions to ask. Most importantly will be which different partners will be necessary to make this process successful. Collaboration with your community members will be key to creating a successful firearm surrender protocol. So before I get into some of the best practices related to firearm surrender protocol, I wanted to see if you could all take a moment to raise your hands or use that little raise your hand option if your community has started a surrender protocol. I'll give you a moment to do so. Okay, so it looks like no one is raising their hand, which is not surprising and pretty typical. But now, could you raise your hand if you started any discussions related to a surrender protocol within your community? Okay, so got a couple of folks, and that's great. Having the conversation is really the only place that you can start. All right, great, thank you. So, I mean, I think that's telling that, so few people are even having these conversations. And, conversations don't require a lot of folks, but it can really start that ball rolling in just having awareness of how important these surrender protocols may be for your community. So I definitely encourage you, if you're interested, to start thinking through some of these practical implications of surrendering firearms. So this first slide is going to provide some of the questions that you'll want to answer, as well as consider prior to the start of any surrender protocol process. So even just those initial thoughts and conversations. So there's some logistical pieces, like who should the guns be surrendered to? So there are some communities that have an agreement with a local gun range, and that's where those guns are stored. Whereas there's also conversation about should the guns be surrendered to law enforcement? Should they have to go to the police department? Should they be keeping those guns in their car? Should they be taking them in with them? What does that look like? Additionally, how quickly after the individual becomes a prohibited possessor should the guns be surrendered? And so again, that's important to think through like those pieces as to how long it should take, what timing that prohibited possessor should be told or informed of. And again, that may look different depending on the resources that you have in your community to be able to respond to this type of surrender of firearms. And again, so these are just pieces to think through. There's no right answer. It can be very, very different depending on your community. It's also important to determine if there's any policies that are currently in place that might be a barrier, that you might need to work within that framework, or something you might need to address right from the beginning and really have, be able to talk through. You'll also want to consider what the process will look like for violations. So really a way to hold the prohibited possessor accountable and ensure that they're following through with that surrender process. And one of the most important pieces will be keeping safety at the forefront. We talked a lot about the risk factors involved with firearms. So considering the safety of the victim, the entity or the people to whom the gun is going to be surrendered, law enforcement who may be enforcing the surrender protocol, and the community generally. So really making sure that you're accomplishing that gun surrender in a way that's safe for everyone involved. Another piece to consider is how you accurately and effectively obtain the necessary information about the number and types of firearms that a prohibited possessor may have. So this will really assist with the surrender process and keep all parties aware of the potential risks that may be in place. So I know that one particular community that had moved forward with the surrender protocol, they have an affidavit that a defendant is required to sign if they state that they do not have firearms. So that way there's something in place that's trying to keep them accountable. So we also know that there's going to be a need for some balancing and evaluation in place for any new protocol. So these are going to be some of the pieces that can be discussed with your community partners to determine whether your protocol is successful or if some tweaking will be required. So first, you'll want to look at how you're going to define success. So it can be really difficult to prove that less injuries, less homicides, less assaults have happened because it's difficult to prove a negative. So being able to think through a metric for success can be really helpful throughout your process, throughout your evaluation as to whether or not things are working. You'll also want to consider the overall value of a surrender protocol in your community. So, I spoke about, not necessarily having the resources generally, to accomplish certain things. So you want to keep those things in mind so that you're practical when it comes to what you're putting into place. So some things like political ramifications. We know that this is real in some communities in Texas. And again, want to be realistic about some of the barriers you may face, and they're important to identify right off the bat. You'll also need to consider the cost of the process. So cost for staff who are enforcing the protocol, the storage for firearms, creation of forms for the process potentially, among other things. You'll also want to consider how this may affect court time. So it's possible that a successful protocol may require extra or longer hearings, or it may streamline some judicial processes. So along with the other potential costs, you'll also want to weigh those against that cost of life. Just really the goal of making your community safer, and the concerns around prohibited possessors not surrendering their firearms. A firearm surrender protocol will also require some broad support across the community. So really making sure that you have those who are involved are fully supportive of the protocol you put in place will be so important. It certainly cannot be a one-person show. It will also be important for all of the community members who are collaborating to be open about their concerns. Really making sure you're getting all different viewpoints and that they can be addressed before something is put into place that's not going to work. So at the very least, you can understand what those concerns are from each party that will be necessary for a successful protocol. Finally, a successful collaborative atmosphere will help to create a successful surrender protocol. So really being sure that collaboration across different community leaders, government agents is at the forefront, and that will help your community to achieve success in the process. So really being supportive and understanding and encouraging of folks to be a part of the process and making sure that you're hearing them will be really, really important to building that trust and building the relationship that's so necessary for a successful protocol. So these are some of the parties that will be helpful to involve in the process of creating a successful firearm protocol. You'll notice this is a very long list, and it can be tweaked depending on your community, and should be tweaked depending on your community. The hope is that most of these people will be supportive of the mission and goal and helpful in achieving it, or have really important insight to provide to you. So thinking through the best way to gain support from these allies and include them in the protocol creation in some way will be necessary. So this doesn't mean that you need to get all of these people together in a room. This just means that being able to get insight from these folks will be very beneficial and helpful. We also understand that there may be some parties that are important to consider and possibly include, but may have a more complicated view on the implementation of a surrender protocol. So you'll want to think through how and when to include the parties that may need some additional support, some additional education or training to become allies in the process. Again, those people that will likely, have some pushback or, some critical feedback are sometimes the most important people to bring in at the very beginning, because that way you're not facing that as you're moving forward in the process. You're facing it right at the beginning. So there are also some other parties that are really important to consider, and those are going to be the voices of the survivors of family violence in your community, as well as families of victims of family violence. and other firearm-related violence, as well as communities that may be disproportionately impacted by certain procedures or like processes in place. So again, all of this will look different for each community. So again, it's really important that none of these suggestions are taken word for word, but you're spending some time thoughtfully determining what steps would work best for the survivors in your community. So all that being said about best practices and how you can start the process of implementing a successful firearms surrender protocol, we understand this may not be easy in many communities across Texas. And I think we already saw the indication that most folks aren't even having the conversation about surrender protocols, and we understand and we know that it's not easy. So what I provided with you are simply best practice ideas with the understanding that your community may not be in a place to implement them at this time. This is the ideal, and it may not be possible for all communities. So I just wanted to provide you with some of those things. And I also wanted to spend some time talking to you about how you, as individuals and within certain professions, what you can do to support survivors if you're not at the surrender protocol implementation or discussion point just yet. So first, let's talk about advocates and allies. So these suggestions can cross many disciplines, and I think can be helpful to most folks who are on this call who work directly with survivors or have some interaction with survivors. So I'll be sure to provide these slides so you have all the necessary information, but I will go through some highlights. So one of the most important things you can do prior to working with survivors who may have been impacted by firearms or other threatening behavior is to really consider what biases you bring to the table. We know we all have innate biases based on our upbringing, our socioeconomic status, our demographics, and the work that we've done in the past, and who we've worked with in the past. So this will be really important to identify internally so that you're at the very least aware of these biases prior to working with a survivor and supporting their specific needs. Another thing you'll find, and a great first step, is being on this webinar, so thank you again for joining, is it'll be important to be knowledgeable about the law so that you can accurately provide risks and benefits about certain choices to the survivors that you're working with. I've also provided a list of questions that may be helpful to ask a victim during your initial contact so that you can safety plan accordingly. So questions like, does your abuser own or have access to a firearm? Okay. Has your abuser ever threatened you with firearms or ammunition directly or threatened to shoot you, a family member, a pet, or themselves? Nope. Has your abuser ever displayed or shot firearms during an argument, incident, or threatened other violence? And what are your biggest concerns about your abuser's firearms? And what would be the safest way to address your abuser's possession of firearms? And of the utmost importance, we'll be listening to the survivor's concerns and experience because ultimately, and this is really important to remember, the survivor is going to know their situation best. They've been the one who have been living it. So some additional safety planning concerns related to firearms would be the continuous readdressing of the safety plan, because we know things can change really quickly. I talked a little bit at the beginning about how dangerous it can be for a survivor who's leaving a relationship. And so as things progress in a criminal case or with a protective order in a relationship, it'll be really important to readdress that safety plan surrounding firearms and what that survivor can do, some options that they have to protect themselves. Also thinking through if there would be an impact on the survivor's safety if the abuser was required to surrender their firearms. So I think there'd be some cases where this would certainly positively impact the survivor's safety, but there may be some instances where it would negatively impact their safety. And so at any point, it's important to identify this to see if it would require any additional safety precautions. Another thing to do would be keeping phone numbers to law enforcement or ATF, which is the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Accessible. That can be really helpful for any quick action that you may need to take. Also, there will likely be survivors that you work with that are interested in obtaining a firearm for their own safety. This is certainly possible and understandable. Being able to discuss the pros and cons to that form of safety planning, for you to encourage safety precautions surrounding the storage and the use of that firearm, as well as staying aware and providing some insight to the survivors that guns are 100% more likely to be, or 100 times more likely to be used against women by men than they are by women protecting themselves. So whether the gun used to kill the woman belongs to the murdered woman or the abuser really doesn't matter at the end of the day. So now I'm going to go into some considerations and thought for folks within the justice system. Having looked at the registration list, I'm hoping to provide everyone on the call with some considerations specific to the role that you have. That being said, I'm hoping that you can take these thoughts and take these slides and you can share them with the folks that you're working with within those systems. So even if you're not within the justice system, even if you're more advocacy-based, these are going to be helpful pieces for you to potentially keep in mind and share with those systems as you work with them. So because law enforcement is often the first responder, they're often the folks that encounter the more dangerous offenders, and the folks that may receive the most information the quickest. There are quite a few things for them to consider and for you to share with those law enforcement partners that you have. As I mentioned before, the lack of timely entry into TCIC, that Texas Crime Information database, can have a really large effect on safety for both survivors and law enforcement. So this is why it'll be so important for law enforcement to enter those magistrate's orders of emergency protection, any other protective orders, and any other bond conditions into TCIC as quickly as possible. Law enforcement will also want to work quickly when a licensed firearm dealer requests a record check to be sure to inform them whether or not that transfer is prohibited or not. Law enforcement also can and should escort a victim to their residence if they can to promote safety for that victim, particularly after the filing of a protective order or some sort of arrest. Additionally, law enforcement can and should enforce out-of-state protective orders if they have probable cause to believe one exists or one is shared with them. So that's important to remember that Texas law enforcement has the ability to serve and enforce a foreign or out-of-state protective order. There are also some legal grounds related to surrender for the removal of firearms for law enforcement to be aware of. So first, if they're provided with consent of both parties, then law enforcement can remove those firearms. So this is specific and based on Texas because Texas is a community property state, so spouses typically have equal control over belongings within the household, which is why you have to ask both parties and have consent of both parties. Also, if the firearm is in plain view and law enforcement is aware that the owner is a prohibited possessor, they're able to remove that firearm. Additionally, under emergency circumstances, there can be a removal of firearms, or if a search warrant is in place or if there's a court order of removal, then law enforcement will have the legal grounds to remove a prohibited possessor's firearms. There are also certain times that would be the most effective to accomplish the removal. So that would typically be after a magistrate order of emergency protection or MOAP. You'll see that on the screen. Prior to a plea, if possible. Sometimes that may not be possible, but that can always be very helpful to more proactively be able to accomplish a surrender. Or after the victim court prosecution or probation notification. So after that notification is made, that's another good time to accomplish that surrender. A few other considerations for law enforcement to think through would be the logistics of surrender, like where will the firearm be stored or surrendered? How should the prohibited possessor surrender their firearm? So I know I mentioned some of these pieces before, but should they just show up? provide notice to the law enforcement officer, enter the building, leave the gun in their car. Also, how should the case be referenced to make sure that they're able to prove their compliance? That's another thing to think through. How should the folks that are storing the firearm follow up if a protective order expires and that person is no longer a prohibited possessor? Also, thinking through what that policy should look like for officer offenders. So law enforcement should think through those internal policies. Also, thinking through how to dispose of a firearm if it does not get retrieved after a particular span of time. So there could be instances where the person is no longer a prohibited possessor, but they never come to pick up that firearm again. You know, figuring out what process would look like for the destruction or the notice of that destruction, or, you know, keeping it, you know, within a particular location for a certain amount of time, or taking that into the law enforcement arsenal of firearms. And finally, as with any discipline, and you'll notice that I'm going to mention this with all of them, ensure that you're updated on the law and that your unit or department is also trained on the current laws. And I know I'm running out of time, so I'm going to try to go quickly through this. We don't have very much left. But the next people I'm going to talk about are considerations for prosecutors. So some things that can be helpful for prosecutors to implement will be explicitly including a prohibition of firearms within any plea agreement. So really making it clear, even though they may not, just based on the type of charge, be able to possess a firearm, making it as clear as possible can be extremely helpful. Also making it really clear in all protective orders as well. Okay. There also might be ability for a prosecutor to make the proof that an offender has surrendered their firearms a requirement of a plea. So prior to allowing them to plea, requiring them to surrender their firearms, or immediately making them surrender those after a plea and have a process in place for checking them. Prosecutors should also think through the creation of forms for the prosecutor and court file that will help to maintain all this information. And then also, when will the guns be returned if they are surrendered? And then, as I already mentioned, that everyone in the prosecutor's office has been trained on the law. So finally, because I know that there are or were some civil attorneys who'd registered for the webinar, I wanted to talk a little bit about those considerations for civil attorneys who work with survivors. So on this one, I'm going to start with training on the law, even though that was across the board something that's super important. Because without training, you'll be unable to have an informed conversation with your clients during intake and throughout the case about both parties' possession of firearms, along with any threats that have come along with that possession or access. Civil attorneys will also want to be aware of other community resources so that they can be provided as referrals for the survivors who may need additional support. We know that not everyone is an expert when it comes to family violence, and so locating and having a relationship with your local family violence program can be really beneficial for the survivors that you're working with. You'll also want to have a discussion about whether or not to include allegations of family violence in your pleadings, so whether this will impact the survivor or the survivor's family's safety. You'll also want to think through the prohibition of firearms while a case is pending. So thinking through if a restraining order is in place, or if you want to have some sort of prohibition of firearms during the exchange or visitation of shared children. Some other considerations include including a protective order in a divorce, the award of pets in particular orders, as well as the award or requirement of the sale of firearms and property division. So again, just some other little pieces that can be helpful when working with a survivor who may have an abuser who possesses firearms or has threatened with firearms in the past. Okay, so I think I'm right at time, and I know that I provided you with quite a lot of information. I hope that you were able to gain some knowledge throughout, particularly those folks who joined us from out of Texas. Again, I know that Brooke is planning to be providing these slides. I'm sorry, Brooke, were you saying something?
Oh, no.
Okay, I think I was just echoing.
Okay.
But it looks like I don't have a whole lot of time for questions. I will put up my contact information, so For anybody who would rather reach out to me directly, or if there's additional questions that come up after you've gotten off the webinar, I really encourage you to reach out. I'm really happy to have any conversation you think is beneficial. I do have some experience with some communities that have implemented a surrender protocol, so I'm always happy to talk about what they've faced and what they've encountered, if that would be helpful to your process. Otherwise, I wanted to thank you all for joining me, and like I said, please reach out if you have any questions.
Thank you so much, Alex. This was a ton of information to cover, and it was so clear and succinct, so I really appreciate you. And yes, like Alex said, watch your email this week for the PowerPoint, but also a recording of the webinar, and then that survey that I talked about, the evaluation that will link to your accreditation certificate. So thank you, Alex. Thank you all for attending. Please feel free to reach out to Alex's email or to me if you have any questions at all, and I hope that everybody has a good rest of your week.
Yeah, thank you again, everyone.
Thank you.